Please, Your Lordship.
Yes.
Lordship, I have one unlisted item.
Hmm.
WA C65 IA C65 of 2025. It's regarding a temporary injunction, short 4, in connection with RFA 1 of 2025, which is pending. May be taken up after part 1, if Lordship finds it
You want it
convenient.
to be listed for orders?
Uh,
For what?
to be, yes, no, if it can be taken up today. I'd
As
like
what? For hearing or for
No,
admission or
not
for orders?
for hearing,
Sorry?
for orders.
For orders?
Yes.
Today?
Yes, Your Lordship.
What is the urgency?
Urgency is that in the suit premises, construction is going on. And this, in spite of the fact that appeal has been filed.
We can have it tomorrow, Mr. Ramzawan.
All right,
Today,
all right,
today we have some part-heart matters. I would like to concentrate on that.
all right.
It might take some time. Okay, tomorrow.
I seek your lordship's indulgence, my lord, in making a mention of item number 9, my lord, of hearing list, my lord. My lord, I am for the respondent number 2 in this case. It's a criminal appeal, my lord, preferred by the victim family, my lord. And the state is the respondent number 2, my lord. The state responds, my lord, they are having 2 fixed items today, my lord. So we also need some time for preparation. So if this matter may be taken after a week, my lord. We have taken the consent of each other, my lord.
Where is Ms. Valentina? Has she come? What is the position? Have you found out? In respect of your item number 3. Why I'm asking is because you see, your case, the judge, the term of sentence, I think it has been completed. You were convicted for a certain period of time. I think it was simple imprisonment for 3 months
My lord,
and a fine of rupees 1,000.
my lord.
Judgment was passed in the year 2019. So you have completed, the accused person has already completed term. Whether appeal should still be heard on merits. Similar issue cropped up in item number 3. So I'd ask Ms. Valentina to look into it.
Yes, my lord. The convict appellant was contacted, and he has been explained the possibilities of the cases. However, he has instructed that the case may kindly be disposed, since he have already completed this the jail term.
No, that is one thing.
Yes.
You've contacted your client is one thing, but the other part is what is the position in law?
In my humble opinion, my lord, after going through the case, I think there is merit in his case, my lord, because there is no solid evidence against him.
No, that is not the question.
Yes.
Ms. Valentina. Thing is that, should we say that the term is completed and matter is in fructose and disposed of?
Yes, my lord.
Or we should still look into the appeal and decide the case on merit?
Yes, my lord.
No, don't say yes. I'm asking
No,
you
no.
to look into that.
I understand, my lord. So, in my humble opinion,
Whether we just ignore and say that term is over, so there's no point in deciding. It's only it's for academic reason that we have to go into this appeal again, since the term has already been served by the prisoner.
my lord.
So it is closed as infructuous. That is one part.
Yes.
Other part is no. Even if the term is completed, the person is convicted, and his name and everything is tainted because he's been convicted in a criminal court. One may still want to pursue the appeal. So what the court wanted to know was, should we still hear the appeal? Whether the appellant wants to continue with the appeal or not is a different thing. Question was the legal provision in law. Legal provision in law.
Yes, my lord.
Because if it's a civil case or say a writ petition, a person was asking for promotion. During the pendency of the writ petition, he is promoted. then he'll say that it fractures. Okay, it fractures. Closed. But can that be done in a criminal case? Person is convicted, sentenced, he served the entire period of his sentence, but case was still pending. And when the case was taken up, the party says that I have already completed my term, let it be closed. So even if that's the demand, what will be the position in law? This is what I wanted to know.
My
So
lord,
your case, item number 3 and item number 9 are more or less similar.
Yes,
They
ma'am.
also they were in prison for 3 months only.
yes, my
That
lord.
was in 2019. And if the imprisonment was in 2019, and of course the appeal is also of 2019. PP, what do you say? Can you throw some light in this?
In some instances, my lord, if the appellants, they are willing, if they are willing, then we close the matter as infractions.
I think we should still look into the matter. Whether you can use the term as infractures or you withdraw the appeal. Or what would be the provision? Mr. Saurabh, you wanted some time.
My lord.
Or what? Why?
My lord, she is already having 2-3 fixed items, my lord.
Oh, because of that.
My lord.
On the prayer made by the learned counsels for the parties, matter stands adjourned for 2 weeks. Stop. The learned counsels shall also address the court as to whether the appeals should still be heard despite the appellant already having undergone the term of imprisonment, which was for 3 months and with fine of rupees 1,000. As per the decision of the trial court, by judgment and order dated 24/4/2019. Okay, please examine this aspect.
My lord, my lord. Yes.
Whether we can just say that, okay, person has already completed 3 months, so no point in hearing the matter, it's infractions.
My lord.
Or whether we should say that it depends on the decision of the appellant, whether he wants to go ahead or whether he wants to give up his appeal. Okay,
My lord.
please look into this aspect.
My lord.
So there is an item 9. Any other mention?
My lord, item 10, since we have other hearing matters today, my lord, if it can come up in the next week.
We'll adjourn it for 2 weeks.
All right, my lord.
This is against acquittal.
Acquittal, my lord.
There's no hurry. As paid for by the learned public prosecutor and not objected to by the other side, matter stands adjourned for 2 weeks. All right.
Obliged.
Admission item 1.
Your Lordship, I'm appearing as requested by Mr. Priyangshu Goswami, counsel for respondent number 5.
Yes.
That, my lord, Mr. Priyangshu Goswami is willing to withdraw his vakalat nama, so if the matter be taken up on another fixed date.
He wants to withdraw?
Yes, my lord.
He's for which party?
NPCC.
Why he wants to withdraw?
I do not know, my lord, but he have sent his withdrawal letter to the NPCC also.
Is he the standing counsel or what is he? Engaged counsel.
He's an engaged counsel. my lord.
Engaged counsel,
Yes.
not a permanent standing counsel or
No.
something. Where is the letter? You are assisting him.
No, my lord, he just requested me. He have sent this letter to the NPCC, but he have not yet received any reply or instruction.
Council has not received his fees, so he's not willing to pursue the matter, appear anymore.
Under the given circumstance, Your Lordship, Mr. Roshan Subedi is still there on behalf of NPCC.
No, but is he a standing council or something like that?
He's assisting Mr. Priyangshu, my lord. Mr.
Mr.
Roshan
Roshan Subedi.
Yeah, he's assisting Mr. Priyangshu.
Where is he today?
My lord, he came late because of his the illness of his daughter.
He's here already in court.
No, my lord.
Then you said he came late.
He will be late.
He came means he's already here.
I'm sorry, my lord.
You should say he will be coming late.
Yes, he will be coming late.
So what is to be done?
Not know, my lord. My lord, he requested me to pray to fix the matter on 29th of May, in case he get another instructions from the NPCC. That is the only brief I
So
got,
it
my
appears that his withdrawal is conditional. Only for the purpose of adjourning.
So should I record all these things?
I don't know. That's up to your lordship, my lord.
What is your good name?
Lomo Maralte.
Mr. Lomo Maralte, learned counsel, submits that he has been instructed by Mr. Priyangshu Goswami, learned counsel, for respondent number 5, bracket NPCC. P, isn't it? P for Punjab.
Yes, my lord.
NPCC. That he has informed the respondent number 5 that he will be withdrawing his wakalatnama from the instant case. Since the NPCC has refused to entertain his quotation. Such communication was made to the respondent number 5 by Mr. Goswami on 17/4/2025. Mr. Lomo Maralte, learned counsel, however, submits that the matter may be listed on
29th May, my lord.
29/5/2025. In case there is some development with the quotation submitted by Mr. Goswami to the NPCC authorities. What is the date you said?
29th May, my lord.
29. 29 May is Thursday.
Yes.
Okay. Next para, considering the above submission. Mr. Ramzawa will list it on 29th.
All right. Objection.
Let the matter be listed on 29/5/2025. Stop. It is, however, made clear that if Mr. P. Goswami is unable to represent the respondent number 5, the respondent number 5 should positively make an alternative arrangement so that the matter can be heard. All right.
Lordship,
my lord.
may I make a mention to the fact that even in item number 6, Mr. Priyangshu is appearing on behalf of respondent number 5 to 7. Whether he's making the same submission in this case.
What about 6?
My lord, he also informed me to pray time to fix on 29th of May. But
Similar.
he's not willing to withdraw his Vakalat Naba in this case. Only on item number 1, he's willing to withdraw.
Why is he not here then?
I do not know, my lord. Maybe he's having some personal difficulties. I'm not sure.
All right. See, unless you come up with some story which is believable,
Yes, ma'am.
court will not be inclined to adjourn the matter like that.
Yes, my lord.
On just simply saying that it may be adjourned. On the prayer made on behalf of Mr. P. Goswami, learned counsel for respondent numbers 5 to 7 by Mr. Lomu Moralte, the matter stands adjourned to be listed again on 29/5/2025. Stop. Since no reason has been assigned by the counsel for respondent number 5 and 7, it is made clear that if respondent number 5 to 7 is unrepresented by the next date, court may consider proceeding with the matter. All right.
Yes, my lord.
Lordship, this matter is analogous with WPC number 12 of 2023. 2022, which is not listed here, may be clubbed with that WPC 12 of 2022.
As paid for by Mr. Sheila Ramzawa, learned senior counsel, appearing for the petitioners. Let WPC number 12 of 2023 be clubbed together with the instant case. Since it is submitted that it is a similar or analogous matter.
God bless.
All right.
Obliged, my lord.
Item 2.
If I have produced the reports,
Where? Have you flagged the portions?
yes, my lord. Note sheet at page 56. It started from there, my lord. And at page 61, my lord. They have made certain points which has to be taken into account while considering the application.
Page 61.
61.
You have not flagged page 61.
No, my lord, it's all from 56 onwards.
Yes, 61.
Page 61. While considering application for grant of compensation allowance, the main points usually taken into account are actual misconduct or course of misconduct which occasioned the dismissal or removal, and the kind of service he had rendered. The applicant in the instant case, Pusiel Thiang Tima, was an assistant convicted by a law by a low court in a criminal case of murder and dismissed by the disciplinary authority. And on point 5, the disciplinary authority may peruse and decide whether compassionate allowance should be granted to the said Pusiel Tiang Lima, and if yes, the amount may be decided. And they have regretted the application at page, in the same page, my lord, the application does not reveal any tangible justification for compensation allowance, for compassionate allowance. His medical needs would obviously be addressed by the prison authorities. Application is therefore rejected. So, my lord, they have taken into account the actual misconduct, and they have also highlighted that it's a case of murder. So,
So this is the reason.
yes, my lord, the reason is given. In that case, my lord, the case is squarely covered by the citation which my learned friend has produced.
Okay, let us go to the citation again.
Two 2014, volume 11. From para 14.
One of you read. Who will read?
My lord, 14.
You're reading from your
My
phone.
phone, yes, my lord. So,
You have a printout. You have a printout.
Yes, madam.
Let him read out the printout. It'll be easier. Yes. Aggrieved?
Paragraph 14.
You read from paragraph 12.
Aggrieved with the order of the tribunal dated 28/2/2006, the appellant filed writ petition number 14924 of 2006 before the High Court. The High Court examined the submissions advanced on behalf of the appellant. It dismissed the claim of the appellant for compassionate allowance on the following consideration. Considering the aforesaid plea, we had directed the petitioner to file an additional affidavit to give particulars and details of the reasons which constrained him to avail leave without pay and to set out other special circumstances in support of his plea for compassionate allowance. The additional affidavit was not filed within 2 weeks as directed. However, further time was granted by us to the petitioner for filing the additional affidavit via order dated 11/10/2006. The additional affidavit that has been prepared by the petitioner, unfortunately, apart from mentioning in para 6 that the petitioner's condition was pathetic and his wife has suffered from cancer and that he was apprehending amputation of his left leg below the knee, does not contain any averments with regard to the various bereavements suffered or the illness of his wife or the treatment thereof and the respective deaths which came into the way of the petitioner from taking legal remedies. He has not brought forward any extenuating and special circumstances which had continued since then which had prevented him from taking timely remedies or would entitle him to compassionate allowance. The medical certificate of the petitioner no doubt shows that he is diabetic and under treatment, therefore. However, it also shows that the petitioner has been a chronic alcoholic and drug addict. Considering the aforesaid factors, while one may sympathize with the petitioner's present condition, we are not satisfied that the petitioner has succeeded in making out a case for grant of compassionate allowance and the discretion exercised by the authorities cannot be said to have been vitiated by any extraneous or irrelevant factors. Paragraph 13. We are of the considered view that the adjudication by the courts below with reference to Rule 41 of the Pension Rules 1972 is clearly misdirected. The rule itself contemplates payment of compassionate allowance to an employee who has been dismissed or removed from service. Under the punishment rules, the above punishments are of the serious magnitude. These punishments can be inflicted only for an act of extreme wrongdoing. It is on account of such wrongdoing that the employee concerned has already been subjected to serious form of punishment, sometimes even for being incorrigible. Despite that, the rule contemplates sanction of a compassionate allowance of up to 2/3 of the pension or gratuity or both, which would have been drawn by the punished employee if he had retired on compassionate pension. The entire consideration up to the present juncture by the courts below is directly or indirectly aimed at determining whether the delinquency committed by the appellant was sufficient and appropriate for the infliction of the punishment of dismissal from service. This determination is relevant for examining the veracity of the punishment order itself. That, however, is not the scope of exercise contemplated in the present condition, insofar as the determination of the admissibility of the benefits contemplated under Rule 41 of the Pension Rules 1972 is concerned. The same has to be by accepting that the delinquency committed by the punished employee was of a magnitude which is sufficient for the imposition of the most severe punishments. As in the present case, unauthorized and willful absence of the appellant for a period of 320 days has resulted in the passing of the order of dismissal from service. The punishment inflicted on the appellant has been found to be legitimate and genuine, as also commensurate to the delinquency of the appellant. The issue now is the evaluation of claim of the punished employee under Rule 41 of the Pension Rules 1972. Paragraph,
At 14.1.
paragraph 14.1 was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service, an act of moral turpitude. An act of moral turpitude is an act which has an inherent quality of baseness, vileness, or depravity with respect to a concerned person's duty towards another or to the society in general. In criminal law, the phrase is used generally to describe a conduct which is contrary to community standards of justice, honesty, and good morals. Any debauched, degenerate, or evil behavior would fall in this classification. 14.2 was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service, an act of dishonesty towards his employer. Such an act of dishonesty would emerge from a behavior which is untrustworthy, deceitful, and insincere, resulting in prejudice to the interest of the employer. This could emerge from an unscrupulous, untrustworthy, and crooked behavior which aims at cheating the employer. Such an act may or may not be aimed at personal gains. It may be aimed at benefiting a third party to the prejudice of the employer. Was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service, an act designed for personal gains from the employer. This would involve acts of corruption, fraud, or personal profiteering through impermissible means by misusing the responsibility bestowed in an employee by an employer, and would include acts of double dealing or racketeering or the like. Such an act may or may not be aimed at causing loss to the employer. The benefit of the delinquent could be at the peril and prejudice of a third party. Was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service aimed at deliberately harming a third party interest?
Okay, Mr. Okuma, which one of these is attracted in your case?
In my humble understanding, the moral turpitude, man. 14.1.
Which one?
14.1.
If that is the case, the conclusion here is that if it's attracted, it will disentitle the employee from such compassionate consideration.
My lord. But my lord, the issue
This
here
is
is
against you. Against you.
exactly, my lord. But the issue here is that compassionate allowances were granted to persons falling under 14.2, my lord. Acts involving corruption, double dealing, or racketeering. My lord.
Maybe. Two
And
wrongs don't make a right. Supposing somebody was wrongly given compassionate allowance,
My lord, that special consideration has to be.
despite one of these conditions being attracted, Can you draw a parity on that, that I also should be given like that? When you also say that you are covered by 14.1,
May I take your lordship to the guidelines framed by the
by,
guiding principles for grant of compassionate allowance, the Government of India's decision, my lord.
Where is
In
that?
page 106 of the pension rules.
you have the pension rules? Are we holding the same book?
Yes, we have the
Page-
same book.
page
Page
number?
106.
Yes, 106.
Government of India's decision. Point 2, my lord.
Hmm.
Guiding principles for grant of compassionate allowance. It is practically impossible in view of the wide variations that naturally exist in the circumstances attending each case to lay down precise principles categorically that can uniformly be applied to individual cases. Each case has therefore to be considered on its merits, and a conclusion has to be reached on the question whether there were any extenuating features in the case as would make the punishment awarded, though it may have been necessary in the interest of government, unduly hard on the individual. In considering this question, it has been the practice to take into account not only the actual misconduct or course of misconduct which occasioned the dismissal or removal of the officer, but also the kind of service he has rendered. Where the course of misconduct carries with it the legitimate inference that the officer's service has been dishonest, there can seldom be any good case for a compassionate allowance. Poverty is not an essential condition precedent to the grant of a compassionate allowance, but special regard is also occasionally paid to the fact that the officer has a wife and children dependent upon him, though this factor by itself is not except perhaps in the most exceptional circumstances sufficient for grant of a compassionate allowance. That is the guiding principle, my lord. In the present case, my lord, it was only the actual misconduct which was taken into consideration, not the service that was rendered. Given the fact that he was a meritorious person, being awarded commendable awards on various occasions prior to his dismissal and subsequent to his dismissal by the competent authority, that implies a special consideration, my lord, in my humble understanding. May I take your lordship to page 75 and 76 of the petition? It's a letter issued by the Secretary Mizoram Scholarship Board and the Controller Printing and Stationery Department, wherein they have acknowledged the service rendered by the petitioner. He was an assistant, my lord. Yes. Oh, my lord.
Commendation?
My lord, the letter speaks itself. May I read, my lord?
Yes.
This is to certify that Pu CL Thiang Lima, assistant, is personally known to me. He is very brilliant and efficient in all kinds of official works, especially in establishment and accounts matters. Moreover, different new schemes of post-matric scholarship which were financially assisted by the Government of India, Ministry of Tribal Affairs, stipend and book grant, which financially assisted by Northeast Council, incentive cash award to the successful candidates of UPSC and research fellowship to the scholars of PhD and MPhil, etc., had been implemented during his tenure in this department, that is 2003 to 2007 by the department, on his efficiency in his official works. That is by the Mizoram Scholarship Board Secretary. And the next page, page 76, was issued by the Controller Printing and Stationery Department. This is to certify that Pu CL Thiang Lima, assistant of this department, who dismissed from service, is personally known to me. He is very brilliant and efficient in all kinds of official works, especially in establishment and account matters. no pending case of promotion cases, pension cases, etc. during his tenure in this department. Moreover, new scheme of strengthening of government press ISO at the cost of 8.42 crores has been implemented by the department, for which Government of India sanctioned under NLCPR during his tenure in this office on his efficiency in his official works. That is the service that he has rendered.
So these are from the Controller Printing and Stationery and from the Scholarship Board.
Yes, madam.
If you see the date of issuance of these certificates, they seems to be quite close by, 24/6/2013. And one is 21/6/2013.
My lord.
Okay, its tenure was different. One tenure was in 2003 to 7, correct?
Yes, my lord.
And the other tenure under the controller,
Under the controller, my lord. Dismissed from service. My lord, my assumption is that this must be subsequent to his reinstatement. That is beyond 2000 to 2007. He was initially dismissed, suspended, and later on reinstated.
so you are convicted of 302.
302.
Who was the victim? Your colleague?
No, my lord. A young man of 24 years during that time. He was a friend. Actually, he was not a relative, no. He was a friend.
How did it happen?
He shot him in his head.
There was a fight.
No, my lord.
Then it was an accident.
Actually, he was, the scenario is that he was standing at the door, and the guy who the deceased told the owner of the house to to shut the door on his face. And being angry with that, he grabbed a pistol and shot the deceased.
In anger.
In anger, yes.
Okay. The citation which you just read is regarding unauthorized absence for 300 and odd days, for which he was dismissed or removed from service. But it's not a case that he wasn't in prison. Despite being in prison, he was being given this compassionate allowance. Is there any case as such which you have produced so far regarding
Yes, my lord. The
allowance despite you have been convicted and in the prison?
in the second citation, which I have marked as 2, Anadioram. The decision was rendered by Bombay High Court. That was also a case of 302, and on appeal, the charge was altered to 325, and the petitioner, all the way to the Supreme Court, had filed SLP claiming for reinstatement. However, that was dismissed. But one specific order was made by the Supreme Court in this regard to allow the petitioner to claim for compassionate allowance. That specific order was passed by the Supreme Court, and it was reflected in this judgment as well. And pursuant to that, he had claimed the compassionate allowance, and that was allowed.
Where is that? Supreme Court had given the relief, I think.
No, my lord, this is a decision by the Bombay High Court.
I mean, sorry, the Bombay High Court.
The first paragraph, my lord. He filed, lordship has that portion.
Which one?
He filed his special leave petition before the Supreme Court. The apex court, while dismissing the special leave petition, however, granted liberty to the petitioner since deceased.
No, from where are you reading?
Anna Dioram Lode, the Bombay High Court.
Correct. Which paragraph? From which
Paragraph
part?
1. Paragraph 1.
The petitioner since deceased. This is how it starts.
Yes, yes. And that is the relevant portion is 1, 2, 3, 4. 11th line, my lord.
Yes, read.
He filed his special leave petition before the Supreme Court. The apex court, while dismissing the special leave petition, however, granted liberty to the petitioner, since deceased, to make a representation to the government that, in spite of his removal, he was entitled to compassionate pension under Rule 100, read with Rule 101 of the Maharashtra Civil Services Pension Rules.
So this is where the Maharashtra Civil Service Pension Rules have its own provision,
Yes, my lord.
and similar to the CCS pension rules.
Yes. Same provision with Rule 41. And the crucial observation was in paragraph 7, my lord.
His conviction was 302 earlier, which was perhaps for life,
Yes.
altered to 325. Sentence is 4 years. Paragraph
Paragraph 7.
7.
May I read, my lord?
Yes.
I am in agreement with the finding that for the purposes of considering grant of compassionate allowance, entire service record needs to be considered and an isolated incident of misconduct. However,
Just a minute. Your paragraph 7, my paragraph 7 doesn't match.
I am sorry, my lord. It's the other page, and I apologize.
Which one?
It's the third citation, actually.
Third citation,
The
paragraph
third
7. Yes.
citation. Ex-ASI Shadiram versus, that is paragraph 7. I am in agreement with the finding that for the purposes of considering grant of compassionate allowance, entire service record needs to be considered and an isolated incident of misconduct, however grave, cannot be determinative of the issue, even though dishonesty in service is a significant and relevant factor to be considered, among others, such as financial and personal circumstances of the concerned employee. That is the observation that was made, madam.
But what was the misconduct?
Extortion, illegal gratification, and extortion of rupees 1,000, accepting bribe, in short, man, by a police personnel.
Okay. And the other citation?
My lord, in terms of parity, I would like to refer to the fourth citation. That is State of Karnataka versus Karnataka State, Patel's Sangha. The fourth citation.
So this is regarding employment by the wife and all that.
No, my lord, it's regarding the village offices. Karnataka Village Offices Abolition Act had been implemented, and the village officers, Shanboks and the Patels,
What is the citation?
2007, 4 SCC 207.
Have you given that?
Yes, my lord. I have flagged it as 4.
State of Karnataka. Okay. Yes.
my lord. The facts are in para 2. May I read, my lord?
Yes.
Respondent number 1 is Karnataka State Patel's Sangha, and respondent number 2 is Patel Srinivasa Reddy. The present writ petition was filed by the respondents claiming similar treatment as was given to Shanbok's category of village officers. The contention in the writ petition was that both Patels as well as Shanboks are holders of similar offices within the meaning of Section 2N of the Karnataka Village Offices Abolition Act 1961, hereinafter to be referred to as the Act. After abolition of these village offices, shanbox were granted compassionate allowance or ad hoc pension at the rate of rupees 100 per month with effect from 3/7/1979, and the same was raised to rupees 500 per month with effect from 27/1991. So far as Patels are concerned, their demand for grant of similar treatment, that is, ad hoc pension or compassionate allowance at the rate of rupees 100 per month, was also considered by the state with effect from 1st August 1984, and similarly the enhancement of compassionate allowance was also made to rupees 500 per month with effect from 3/5/1994. And my lord, basically the Karnataka state has challenged the actions of this, and it was accordingly dismissed by the Supreme Court. And the shanbox and the petals were to be treated in parity with their claim. That is the observation made. Likewise, in the case, my lord, if personnels rendering government service were convicted of an offense, it would not be wrong to treat them with the same parity. And my lord, I'll refer to the sixth citation. The sixth citation. Well, basically, my lord, there are two sections in this case: the Patels and the Shanbox. Both are holding offices, village offices, and under the Karnataka Village Offices Abolition Act 1961, they were granted compassionate allowance. But compassionate allowance here might be different and might not be similar to the present contention in this writ petition, but the spirit is quite the same, because they have claimed, the Patels, that the state of Karnataka had challenged the grant of compassionate allowance, which is similar to the Shanbox, association of the Shanbox.
In one hand, but on the other hand, you cannot lose sight of the fact that what was the reason behind for such dismissal from service. This is a case in which ordinarily in a claim made by two sets of categories of officers employed under one particular organization or some particular act has been given different sort of compassionate allowance or ad hoc pension. Without there being any such kind of record of criminal record or being dismissed from service or whatever, isn't it? This is not a case of dismissal from service. In your case, we are concerned with your conviction, and your conviction is one thing, of course. Your dismissal from service. You are dismissed from service, and yet you say that I should be given compassionate allowance, which is permissible under 41. And there are certain parameters under which it can be granted. And if you want to draw a parity, then there has to be some factual background that these two groups, one group was or they were also similarly removed from service. That thing is missing.
My lord, what I would like to state is that
It's a simpliciter citation for parity of the compassionate allowance, minus any such kind of disciplinary action against them.
I understand.
So this will apply in case of two groups of employees. One say that we're not getting this much. How come he's getting this much? Court says that you cannot have a separate rate, give them similar rates. Your case is regarding somebody was dismissed, removed from service after DP, was also convicted by a court, yet he was given compassionate allowance. They say that it is a case of murder, 302 conviction. We have considered, so just taking into consideration the gravity of the offense, we are not inclined to grant that compassionate allowance. But of course, you have raised one issue regarding that the past service rendered by him. That was not taken into account.
Exactly.
That perhaps is the sole point, perhaps, which is available. You have shown me two commendations given to you by the controller and by the scholarship board. I have seen the file, you have not seen the file. They have recorded something here. It's not in many words, but they have recorded something. So perhaps on that note, the service rendered by the employee, Ms. Linda,
Yes, Your Lordship.
there's no mention about his service
My
rendered.
lord, in page 62 in the note sheet.
Is it mentioned?
Yes, he has submitted his appeal. And there he has, in the last para, he has talked about his service records.
No, he's talked about it, no doubt, but was there any discussion on that?
His service records, it's not written, but it's his case has been thoroughly considered, my lord.
You have drawn my attention only to page 56 and 61,
The
isn't it?
dismissal order is at 61, yes.
61.
And the next page is the review that he has submitted,
60, next page means?
62, note sheet.
Appeal.
Yes, the appeal. And this is also regretted again.
Then where is the decision?
At page 74 of the note sheet,
74.
74. As noted at, I cannot read it. Sorry, it's cited. As the last para is already decided, since the crime committed was murder and hence the status quo may kindly be maintained.
Which page?
Page 74.
It's not like that. Okay.
74. Continue from the previous page.
Then where's the approval? Who has taken the decision?
They have referred it to the disciplinary authority. The vigilance department has accepted.
Then what is the outcome?
The outcome, my lord, it's this application is rejected, regretted.
Where do we find that?
My lord, I'll have to see the.
See, what you just read was as already decided at so and so, since the crime committed was murder, and hence the status quo may kindly be maintained and regretted. Then after that, what? Regretted of? So and so. Prayer, please, for kind approval and order, please. Then it was referred to the Secretary DPNR, who writes that the earlier decision may stand. Is that the conclusion?
Yes, my lord. Secretary DPNR.
Was he communicated about his review?
That I haven't checked, my lord. I'll have to check.
So after submitting his first application, it was rejected. Then he submitted an appeal, correct?
Yes.
For reviewing the decision. Now, whether decision was taken and communicated to the petitioner.
Yes, my lord. In my affidavit, I have mentioned.
No, in this file, it should be there. This is your affidavit is based on the records.
Yes, my lord.
So the records should also reveal that the petitioner will be communicated accordingly or something like that.
On 18 November 2021, this is the latest.
18 November.
Yes, madam.
What was there?
At para 11 of my affidavit, wherein we have sent a letter to the wife saying that the prior has been reported.
Okay, just a minute. 75. You're talking about the date 1811. Correct.
Yes.
No, they have prepared a draft, but that draft is not available in this file. I don't know how it should be paginated. Note sheet. You have a copy of the note sheet with you? Soft
No,
soft
no.
copy.
No, my lord. I have only a few pages. So.
Okay. No, they have written here, as per the decision of the competent authority, draft placed below for approval and signed, please. That was on 15 November. And ultimately it goes down, various signatures are there. The last signature is 1811. So that draft should be somewhere available here. I don't know why it's not there. Two 31. Correct, it's here. With reference, so and so is regretted by the competent authority. Page 232. Ms. Linda,
Yes, Your Lordship.
some write-up is there regarding the application submitted by his wife, claiming that he has got good service records and all that.
Yes.
And that has been written in the write-up. But the authority who is supposed to decide perhaps has not examined this aspect. And the main guiding factor perhaps is that there is no room for review. The request for compassionate allowance had submitted by the petitioner himself had been rejected by the Commissioner and DPNR and also by the Principal Secretary DPNR. Meaning thereby that since it was rejected earlier, so there is no question of opening it again.
Yes, Your Lordship.
But thing is that when somebody has mentioned that, see, by these are my records, at least they should examine that. Okay,
Perhaps
doubt.
it was already considered at the first instance, my lord, because it was mentioned that the service records has to be taken into consideration at page 62.
correct. But where
And-
is the discussion?
My lord, the reason why the service records has not been taken into consideration is the nature of crime he has committed. If I may take a lordship to page 28 of my affidavit.
So we have the records before us.
My lord,
What more can
no,
we
it's
say?
the judgment and order of the crime that he has committed. It's not like any other crime.
No, correct. It's a heinous crime, no doubt.
It's written here, my lord, rarest of the rare case.
Correct. It is a heinous crime, murder, 302 convicted for life. But despite such position, Rule 41 provides that one can avail for compassionate allowance,
Yes.
subject to these parameters.
And
And the parameters amongst that, one is that not only the actual act for which he was dismissed, removed from service, but also his entire service career, what he had done. That also we to look into. Now, we cannot guide the authority concerned, but at least he should appreciate those things.
if he is deserving only, my lord, the compassionate allowance can be given only to a deserving.
That is the
man.
ultimate decision, but that decision should be in black and white. Because the clerk concerned, so to say, whoever it may be, the person who is preparing the draft, saying this is the application and for compassionate allowance, and he refers to Rule 41. Under Rule 41, these are the things which are to be considered. So disciplinary authority may decide based on these. And what is written here? The application does not deserve any tangible justification for compassionate allowance and medical leave. And the medical needs may be obviously addressed by the prison authorities. These 2-3 lines is the decision. What I meant to say was that at least there should be some discussion. We are aware he's done all these things, scholarship, whatnot, this, that. But all these things cannot take away the fact that he has been removed from service on account of certain crime which cannot be, by any stretch of imagination, be lost sight of. So the entire thing, whatever claim he make, cannot be. I mean, something has to be discussed. But here it's only just one line. He does not deserve to be given. Medical attention, prisoners, the jail authorities will decide. That much. And thereafter, he has filed 1 or 2 further review or appeal like that. And they said, no, earlier already the commissioner has decided Secretary has decided. So there is no question of opening it again. Status quo should be maintained. This is what we get from the file. So we'll dispose it of. Let them consider under those parameters. Court is not saying that he deserves to be given. I will just say that under these parameters, a thorough consideration should be done. And
Your Lordship, in that light, page 61 has already considered, so if my submission in this regard may be written.
surely, we'll record your submission, don't worry. But please write hard, Mr.
My lord, may I cite this citation?
Which
One
one?
citation. I have another citation which states that by the Supreme Court, which states that if in case there is a I'll just read the relevant provision. It is settled law that when financial rules framed by the government, such as pension rules, are capable of more interpretations than one, the court should lean towards that interpretation which goes in favor of the employee. That is the observation made.
Please write hard, Mr. Larokuma Pautu, Learned Legal Aid Counsel, and Ms. Linda L. Fumble, Learned Additional Advocate General, for the respondents. So by filing this application, the petitioner, who is currently lodged in central jail on account of being convicted under section 302 of the IPC, has sought for compassionate allowance as admissible under Rule 41 of the CCS Pension Rules 1972, and also for encashment of unutilized earned leave under Rule 39, bracket 6, brackets 1 of the CCS Leave Rules 1972. Leave will be within bracket. Next para. Brief facts of the case is that the petitioner was appointed as a Law Division Clerk, bracket LDC, in the year 1976 in the Supply and Transport Department. Stop. Thereafter, he was declared to be quasi-permanent on 23/1979 and subsequently promoted to the post of Upper Division Clerk, bracket UDC, on 25/11/1982. Stop. The petitioner was regularized in service on 10/3/1983. Next para. While the petitioner was serving as such, he was suspended on 15/2/2007 on account of being arrested in connection with a certain criminal case he was thereafter reinstated on 10/6/2008. Stop the petitioner on account of his involvement in the criminal case faced criminal trial. What is the case number and all that? Criminal trial? That is,
Number 199 of 2007.
where do we get that?
Annexure 3, my lord.
That is criminal trial number 199 of 2007. Arising out of bonk on PS case number 71 of 2007 under section 302 IPC. And the trial ended in favor of the prosecution. Stop. The petitioner was therefore convicted under section 302 IPC and was sentenced to rigorous imprisonment for life. White judgment and order dated 19/12/2012. Stop. Following the conviction and imprisonment, conviction and sentence imposed upon the petitioner, he was dismissed from service. White order dated 19/2/2013. And has since been lodged in jail to carry out the term of imprisonment imposed upon him. Stop. It is where is the appeal? Did you give a copy of the appeal? Criminal appeal dismissed.
No, my lord. I did not give.
Criminal appeal is dismissed.
Dismissed, my lord.
It is submitted at the bar that the petitioner submitted an appeal before this court against his conviction and sentence. Do you have the number? No,
Sorry, no.
but the same has been dismissed by this court. Stop. As stated earlier, the petitioner has now filed the instant writ petition claiming for compassionate allowance as well as encashment of unutilized earned leave. Next para. Mr. Aloroku Mapautu, Learned Legal Aid Counsel. Has drawn the attention of this court to Rule 41 of the CCS Pension Rules 1972, as well as Rule 39 bracket 6 bracket small a bracket small Roman 1 of the CCS Leave Rules 1972, to impress upon the court that the petition is entitled to be given such benefit despite being dismissed from service and also convicted by a criminal court. So the learned counsel submits that the petitioner has rendered good service in the past and for which he has received commendation from the authorities concerned. So therefore, the petitioner is entitled to be given the compassionate allowance as well as the encashment of his unutilized unleave in terms of the relevant provisions of law. Stop. The learned counsel has in particular referred to clause 2, bracket 2, okay, of the Government of India's decision under Rule 41 of the CCS pension rules. Wherein it has been stated that each case has to be considered on its merits and a conclusion has to be reached on the question as to whether there was any extenuating features in the case as would make the punishment awarded though it may have been necessary in the interests of government, unduly hard on the individual. So, in considering this question, it has been the practice to take into account not only the actual misconduct, which occasioned the dismissal or removal of the officer, but also the kind of service he has rendered. The learned counsel submits that the petitioner submitted his application for the benefits paid by him in this writ petition before the respondent authorities, but however, the same was rejected. Subsequently, he filed an appeal seeking review of the decision through his wife, but the same was again rejected. Stop. Therefore, having no alternative, the petitioner has filed the instant writ petition. The learned counsel, in support of his submission, has relied upon the following authorities. Number one, Mahinder Dutt Sharma versus Union of India and others, 2014, 11 SCC 684. Number two, Anna Dioram Lodh, deceased through LR Srimati Indrabai and Anna Lodh. Srimati Indrabai, wife of Anna Lodh, versus State of Maharashtra. Number three, ex-ASI Shadi Ram versus Government of NCT of Delhi and others. (2008) SCC online DEL Delhi 1396. Number four, State of Karnataka and another versus Karnataka State, Patels Sangha and another, 2007, 4 SCC 207. What was that last one which you had referred to?
2022, 18 SCC 382. State of Rajasthan versus OP Gupta.
And number five, State of Rajasthan and others versus OP Gupta, 2022, 18 SCC 382. Which is the relevant para?
Paragraph 26 and 27.
The learned counsel therefore submits that the writ petition may be allowed as paid for by the petitioner. Next para, Ms. Linda L. Fumble, learned additional AG, on the other hand, by referring to the affidavit was filed, referring to the affidavit in opposition filed by the state respondents. Submitted. Submits that The petitioner has committed grave misconduct. Which is evident from the fact that he has been convicted by the trial court under section 302 IPC. Full stop. The application for compassionate allowance and other benefit was duly considered by the respondent authorities. And was regretted on 3 occasions. Stop. Therefore, the writ petition has no merit and should be dismissed. Stop. She submits that insofar as the requirement of financial support for proper treatment of the petition is concerned, comma, the medical expenses can be reimbursed by his wife, who is also an employee of the state government. Of the learned additional AG has also produced the records as was directed by this court. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. There is no dispute to the fact that compassionate allowance can be granted under Rule 41 of the CCS Pension Rules 1972 to a person who has been dismissed from service, including a person who has been convicted by a court of law. Did you produce any citation regarding this encashment of earned leave?
I have a citation. I have few citations, my lord. Regarding that, the Supreme Court has held that the citation number 8, my lord, which I have flagged.
Even after conviction? Even after conviction?
My lord, this is a case where the petitioner had retired pending a criminal proceeding, and he has claimed for his leave encashment.
Pending criminal?
Criminal proceeding against him.
Then
He was
what was the direction?
he was eventually granted, my lord, with interest.
No, what happened to the criminal case? Was it completed?
No, he was acquitted of the charge, my lord.
Acquitted. Here is no, you're not acquitted. Now, all these rejection made rejection made by you, I mean, the application made by you has been rejected, speaks only of the compassionate allowance.
Yes.
Doesn't speak about the leave encashment, isn't it? So question is whether leave encashment can be granted or not. Have you raised this issue before the competent authority?
It only came to light in the writ petition, my lord. It was initially it was only the compassionate allowance which was applied for.
So, insofar as the claim for encashment of unutilized earned leave, in terms of Rule 39 bracket 6 bracket small a bracket small Roman 1 of the CCS Leave Rules 1972 is concerned, it appears that the petitioner had not raised the claim before the respondent authority is concerned. And therefore, the question as to whether such leave encashment would be available to a person who has been dismissed from service on account of being convicted by a court of law remains open. Of the apex court, in Mahinder Dutt Sharma, had given an illustration, had given 5 illustrations for evaluating as to whether an employee deserves to be granted compassionate allowance under Rule 41 of the pension rules. The learned legal aid counsel submits that the petitioner may appear to have been covered under the first illustration at paragraph 14.1 bracket small Roman 1 of the said judgment. But however, the illustrations are not limited only to the 5 illustrative points given by the Supreme Court. Stop. While the conduct, the moral and behavior of the petitioner may be one of the factor to be considered. But the past meritorious service rendered by the petitioner cannot be ignored and also should be taken into consideration. As a guiding principle for grant of compassionate allowance, in terms of the Government of India's decision under Rule 41 of the CCS pension rules. He submits that from the rejection made by the respondent authorities, it is clear that such consideration was not done, and therefore they are liable to be directed to give such consideration for grant of compassionate allowance to the petitioner. Reliance has also been placed on the case of Anna Dioram Lodh Supra, wherein the petitioner, since deceased, was removed from service on account of his conviction for offences under Section 302 amongst others. So the High Court had interfered with the conviction under 302 IPC and had altered the same to a conviction under 325, Section 325 IPC. Although challenge made to the conviction was not interfered with by the apex court, but the petitioner was allowed to claim compensatory allowance as admissible in law. of more than one interpretation, the courts would lean towards that interpretation which goes in favor of the employee. Next para, from what has been discussed here and above, it can be seen that compassionate allowance would be admissible to an employee despite having been dismissed from service or having been convicted by a court of law. Stop. However, there are certain parameters under which such considerations are to be made. Stop. I have perused the records produced by the learned Additional Advocate General, which goes to show that the application submitted by the petitioner for compassionate allowance was put up before the competent authority by indicating the parameters under which such consideration can be done, that is, actual misconduct or course of misconduct which occasioned the dismissal or removal from service, and also the kind of service that was rendered. So it is seen that the competent authority has opined that the application does not reveal any tangible justification for compassionate allowance, and his medical needs can be addressed by the prison authorities. Stop. Not satisfied, the petitioner thereafter submitted 2 more applications seeking review of the decision, and also stressing on the fact that during his entire service, he had good records, and he was the backbone staff in the department where he was posted. Stop. Further, he was awarded honorarium in cash and also awarded best performance report from, and also you cut, okay? he was awarded honorarium in cash, okay, while he was posted in the Food, Civil Supplies and Consumer Affairs Department. Stop. He was also awarded Best Performance Report while he was posted in the office of the Controller, Printing and Stationery Department. Stop. Therefore, taking into account the meritorious service rendered by him, and also, importantly, the fact that he was suffering endless medical complications, compensatory allowance, sorry, compassionate allowance should therefore be given to him. Stop. However, the further applications submitted by the petitioner through his wife what did I say? However, was rejected. On the ground that a decision had already been taken earlier and the crime committed by the petitioner was murder, and therefore status quo should be maintained. To stop, in other words, the application of the petitioner through his wife should be regretted. Stop. Consequently, the wife of the petitioner was informed about the rejection of the application on 18/11/2021. Stop. From a perusal of the records, it is seen that though a write-up has been made with regard to the claim made by the petitioner himself or through his wife with regard to the good service record that the petitioner had while in service, comma, there appears to be no discussion or consideration of the same. Stop. In other words, the first application submitted by him, having been rejected, on 17/6/2013, his appeal rejected on 30/7/2013, comma, the third application submitted by him through his wife also stood rejected. Stop. Therefore, apart from the reason for his dismissal from service being the main consideration for rejection of his application for compassionate allowance, comma, the kind of service that the petitioner had rendered while in service appears to have not been taken into consideration. Stop. The petitioner, in support of his contention that he had rendered good service, has also annexed the letter of appreciation and other testimonials issued by the authority concerned in the writ petition as annexure 12A, Roman 12A, comma, Roman 13 and Roman 14. Who will consider this? Mr. Okuma? Miss Linda? He was working under which department?
At the time of his dismissal, printing and stationery department.
See, the writ petition was filed from jail, isn't it?
Yes.
There's no respondent as such. Okay, DPNR is there. Next para, thus upon due consideration of the case in its entirety, I'm able to consider view that the respondent authority should re-examine the case of the petitioner by taking into account the service rendered by him in the past in terms of the Government of India's decision as provided under Rule 41 of the CCS pension rules. So accordingly, the respondent, accordingly, the secretary to the Government of Mizoram, D.P. Nair, do we have to indicate SSW? They have only one secretary, isn't it?
Yes, my lord.
You have GSW, CSW, SSW,
Yes. I think it's under
under one secretary. Secretary D.P. Nair shall undertake the exercise of reconsideration of the case of the petitioner for grant of compassionate allowance in terms of the observations made here and above within a period of 6 weeks from the date of receipt of a certified copy of this order. First of the said authority shall also consider the claim of the petitioner for grant of leave encashment, for grant of for encashment of unutilized earned leave. Do we have the leave rules with us? CCS leave rules. That may be permissible under Rule 39 of the CCS pension rules. I'm sorry, CCS leave rules, 1972. That respondent authority concerned shall take a decision as directed here and above within that time frame by passing a reasoned by passing a reasoned and speaking order which should be communicated to the petitioner. With the above observation and direction, the petition stands disposed of.
I'm obliged.
You are the legal aid counsel, isn't it?
Yes, madam.
Regarding your fees, though, you can submit that, isn't it?
Yes.
There's no order required for that.
I'm obliged.
Item 3.
Miss Linda, you take back the reports. Give her back these reports. Which item is this? Yes. What is to be done?
My lord, if I may, although the convicted appellant has requested the closure of the appeal, however, in my humble opinion, there is a merit in the case and he has a very good chance of acquittal. That is my humble submission, my lord.
But of course, he may have a good case. Question was otherwise, whether we should go ahead, whether cause of action survives, cause of hearing the appeal survives. Basically, if he succeeds in the appeal, it's just to clear his name,
Yes, my lord.
isn't it? Miss Linda and Miss Mary, what do you say?
Lordship, in my humble opinion, I believe that if the appellant wants to close the matter, then hearing the matter would be of empty formality. But if he wants to clear his name otherwise, then we can go on merit because there is no bar to hear the appeal, even though they have served a sentence. But then in this case, if the intention of the appellant is clear, just for closure, and if he doesn't care about clearing his name, then I think it would be a waste of time of this honorable court.
This is an appeal from jail?
Yes.
Okay. He had informed the appellant.
Yes, my lord, he was contacted and explained to him.
Then,
He said, quote unquote, if this matter can be closed, then I will be very much grateful.
okay. So what is to be done then? It's entirely up to him. But I don't think we can say that it is infructuous.
No, my lord.
We
It's
can
not
only say
infruct-
that he is
No,
not
ma'am.
willing to pursue the matter since he has already served the sentence. That much we can say, I think. Because that stigma will always remain. Convicted, okay, you served 1 year, 2 years, 5 years, whatever it may be. You completed your conviction, you're out now. You're a free man now. But there will always be a reference to your case that you were once convicted by a court of law. So should we close it then? What to do?
If the convict appellant is inclined to close the matter, then my lord, then the matter may be closed.
You're an amicus.
Yes, my lord.
What will happen to your fees? No hearing, no fees.
No problem, my
Is it
lord.
okay?
My lord.
Okay. Please write down. Ms. Valentina Laldinpui, learned amicus curiae, submits that although this appeal is from jail, comma, she has contacted the appellant and according to him, since he has already served the term of imprisonment that was imposed upon him, he would no longer, he does not want to pursue the appeal any longer. And that the appeal may be closed. Who is appearing for the other side? Miss Mary,
I am,
or Miss Mary Alcante, learned additional public prosecutor, appearing for the state, submits that she has no objection to the prayer made. In view of above, the appeal stands closed as not pressed.
May I, please, Your Lordship, my Lord, may I just, out of respect to my learned friend for doing the amicus work, my Lord, she have read the file and she have made an effort to reach out the appellant also. Shouldn't she be given at least a little sum of?
Okay, fair enough. But you'll not be entitled to the full fees.
Yes.
No problem, my lord.
5,000. All right. Although the matter has not been heard by this court, the learned amicus curiae, the Mizoram State Legal Service Authority shall pay a remuneration of rupees 5,000 to the learned amicus curiae, Ms. Valentina Aldinpui, for having rendered assistance to this court. Okay.
Obliged.
All right.
Item 4.
May it please, Your Lordship. My Lord, in terms of the order dated 8/4/2025, I was directed to produce the verification report if already prepared, my Lord. My Lord, the verification report is under preparation and I am due to be served a copy of the same by next week, my Lord.
Okay. So we'll list it next week then,
Yes, Your Lordship.
Tuesday?
By Tuesday.
Okay, Mr. Samuel Valansi Ratsanke, learned additional advocate general, submits that the verification report that was sought for by this court will be made available to him by will made available to him within the next few days, and therefore he prays that he may be given some more time. So as prayed for, let the matter be listed again on 6th of May 2025. All right.
Obliged, my Lord.
Item 5.
May it please, Your Lordship. I'm appearing on behalf of Mr. Benjamin in this case, Your Lordship. And he's representing the state respondents. However, he's on medical leave till tomorrow. So the matter may be adjourned today and listed again after 2 weeks, Your Lordship.
My Lord, here order was passed by this honorable court to take up the matter after a period of 2 weeks, and it was also reflected that attempt may be made to dispose of the present matter as speedy as possible, my Lord. So last time they also prayed time forward. seeking the instruction from the government.
What instructions?
Instruction regarding the whether affidavit is to be filed with by the state government or not.
They have not filed affidavit.
Yes, not yet,
They have not filed.
not yet, my lord. With regard to the recast petition,
He has filed recast petition again, and in that matter, they are yet to file counter by the state respondent.
What is new in the recast petition?
that the new in the recast petition is with regard to the implement of the MPSC, my lord.
Only that.
MPSC, Mizoram Public Service Commission, because we are challenging the impine order passed by the MSSB, my lord.
Okay.
After that, the MSSB was defunct,
Hmm.
and due to
Triple SB is defunct now. Now it's everything is taken over by the MPSC.
yes, my lord.
What will the MPSC say? They will say that it was before we were into picture.
The MPSC have
So-
already submitted their affidavit, my lord.
What do they say?
They
That
said
they have
that-
nothing to say.
They say that there is no informity with regard to the order, I mean, the selection procedure, the selection result, which was challenged in this case, my lord.
So they support the Triple SB.
Yes, they support the MSSB.
So if the or recast petition is only regarding implement of MPSC, what is there to comment?
Yes,
What is there
yes,
to file affidavit?
yes,
What affidavit will you file?
exactly, my lord.
Yes, Your Lordship.
Yes. What did she tell you? What did Pinari tell you?
He asked me what about the case.
Because I am not,
File.
the case is not endorsed to me, Your Lordship, so I was not aware of the facts of the case, so I was asking Dinari ma'am regarding the same.
I think the matter is regarding appointment of health worker female
Yes, Your Lordship.
in excess of the quota. Correct?
Correct, my lord.
Suppose 10 is the quota, they have appointed 15 people.
Yes,
Is
Your
it? So he's questioning, how come you have appointed more than the quota?
Yes, Your Lordship.
So next thing now is that he has filed amendment.
Yes, Your Lordship.
And what is the amendment about? That was my question. He says that we have implemented MPSC.
Yes, Your
So
Lordship.
merely implement of MPSC need not be responded to.
Yes, Your Lordship.
Earlier there were board was there. MPSC says that we have taken over now. Whatever was done, we support. That's what they say. So, Mr. Benjamin is supposed to be in this post.
It seems, my lord, yes.
So I think you should have some consideration.
My lord.
If he's unwell, then what to do? When do we list it? When is he coming back?
Your Lordship, if the matter may be listed after 2 weeks, Your Lordship.
2 weeks.
Yes, Your Lordship.
If maybe possible, my lord, after 1 week, my lord. After a week time.
1 week may be difficult. Next week, I think you just have 4 working days.
Yes, sir.
If you want, we can fix it on a date. Twelfth is a holiday over.
Yes, Your Lordship.
Buddha Purnima. You can have it on 13th.
13.
you want a
no,
date?
no
13?
I have no problem with that, my lord.
Okay. Mrs. Dinari and Ms. Luntui. 13.
Yes, Your Lordship.
Although all the parties are represented except for the state government. No, you cancel that order. You just write like this. Mr. Benjamin Lalthamona, learned government advocate, who is appearing for the state respondents. He said to have some personal difficulties on medical grounds an adjournment, and therefore an adjournment has been prayed on his behalf by Ms. Lal Nuntui, learned government advocate. So, considering the said prayer, that the matter be listed on 13th of May 2025 as paid for.
Much obliged, Your Lordship.
Hearing items 7 and 8.